elected for. The LNP will support it, but the broader public need to understand what this government is doing.
Call the member for Noosa.
Thank you, Acting Speaker. Our communities have again had to relive the horrors that convicted child murderer and rapist Barrie Watts perpetrated, simply because he was allowed to apply for parole again. Noosa and the Sunshine Coast communities have been clear through the 72,000-strong petition, and I thank the member for Ninderry for his work on this. Those who commit heinous crimes should not have the ability to continually apply for parole, creating ongoing trauma for victims, families and friends. There is a need to protect Queenslanders from this harm. The Police Powers and Responsibilities and Other Legislation Amendment Bill 2021 proposes a new framework to reduce this retraumatisation. It authorises the President of the Parole Board to make a restricted prisoner declaration on a prisoner who has committed multiple murders or murdered a child, and that this cohort of prisoners must not be considered for parole for a period of up to 10 years. It should be noted that this is up to 10 years, not every 10 years. Submitters, including the Queensland Law Society, Sisters Inside, Prisoners Legal Service and Queensland Council of Civil Liberties, raised concerns, including with the application of parole and that this creates a presumption against parole, is punitive and onerous and provides little further protection to the community. Whilst those concerns are noted, fundamentally it must be remembered that parole is not a right. The setting of an eligibility date by the court does not grant parole, which must always be weighed against its impact on the community and particularly as it relates to the further traumatisation of victims and their families. Several submitters and witnesses at the hearings brought forward their concerns with other aspects of the parole system, which impact detrimentally on both the overcrowding of the prison system and on individual prisoners. Even though outside the capacity of this bill, these must be urgently addressed. These included the timeliness of processing parole, with prisoners who a judge has deemed should be on parole are still waiting long periods due to the backlog of cases. Recommendations that have been put forward by organisations such as Sisters Inside must be considered. This includes whether court-ordered parole could be applied to all cases with, for example, sentences of under 5 years instead of the 3 years as it is now. This would take simple cases out of the purview of the Parole Board and have them processed quickly, which then frees up prison resources as well. In addition, outdated administration processes which prevent all information to be presented at the one time, which slows down the process. They also highlight the need for housing for those seeking parole, especially for those that were homeless before their prison term. Mr Walter Sofronoff QC's 2016 Queensland Parole System Review report had as #1 recommendation that there be a review of the parole system in Queensland in 2022, after 5 years of operation of the new board, to see if the system has improved the processes. It is understood that data collection and preparatory work has commenced, but the terms of reference of the review will be key, and these don't appear to be available yet. There were 91 recommendations in total, of which government accepted 89. The question still remains, how many have been implemented and why haven't the other ones? The Queensland Law Society and the Queensland Council for Civil Liberties suggested that parole hearings should be done publicly, with a judge presiding, as it relates to the rights for prisoners to have criminal charges decided in an open and transparent court. Submitters possibly haven't considered the additional resources this would take and the further slowing down of the parole process. We must remember that a court has already made a determination of guilt and sentenced accordingly. Parole is a decision-making process about what has occurred since that sentence was handed down, and the Parole Board's president is required to have a level of skill, qualifications, experience or standing equivalent to that of a court judge. Further, public hearings would defeat the entire purpose of protecting the families of victims being re-traumatised every time the parole question comes up, which currently could be every year. Ultimately, Queenslanders are not interested in who makes the determination, just that justice is served and systems that do not serve us well are rectified. The bill has additional provisions, including replacing archaic terminologies to ones that recognise and respect the distinct cultural identity of Aboriginal and Torres Strait Islander peoples. As well, sensible amendments to the Police Service Administration Act 1990 and Corrective Services Act 2006 to create new indictable offences for wilfully and unlawfully killing or seriously injuring a QPS dog or horse or a QCS dog. Amendments to the Police Powers and Responsibilities Act 2000 is to dissuade the unlawful carrying of a knife in a public place. Several submitted argued that these amendments aren't preventative, rather punitive in nature, and will prevent people from attending the banned areas at other times when they might be seeking medical support or employment services. However, they only need not carry a knife. Lastly, amendments to the Police Powers and Responsibilities Regulation 2012 are to permit QPS civilian employees and contracted translators working as monitors to utilise surveillance devices without constant police presence. While this change may free up police time, QPS should monitor the implementation of this amendment to ensure that the surveillance remains appropriate and does not impact on possible future evidentiary matters. In closing, I thank our Chair, fellow committee members and Secretariat for their work. Thank you also to the Minister, who listened to the calls for this change from the Kinney family and through Shan's Law. Also, submitters, attendees at public hearings and briefings in the examination of this bill. And again, thank you to our incredibly hard-working police for what you do every day. Thank you.
Deputy Speaker.
Call the member for Cooper.
Thank you, Deputy Speaker. I too rise to make a contribution towards the Police Powers and Responsibilities and Other Legislation Amendment Bill 2021. As others have done, I would like to start by thanking my fellow members of the Legal Affairs and Safety Committee for their work on this, and to thank the Secretariat also for their work and for managing the volume of work that they have, and for managing us as a committee. I think is a fantastic effort on their part. I'd also like to thank, as others have, those who made submissions, and I think it's important to acknowledge that that the committee has worked on a few bills recently that have drawn from the expertise of particular services and agencies, and in addition to running their services, they're also responding to our committee, providing really thorough, comprehensive, detailed, well-researched submissions, and we couldn't do this work without them, and I just would like to specifically acknowledge them in this as well. The bill includes important... so the committee made one recommendation that the bill be passed. The bill includes important amendments to reduce the re-traumatisation of victims' families, to provide clarity to our laws where clarity is needed, and to create efficiencies for the Queensland Police Service. Amendments to the Corrective Services Act will strengthen the no body, no parole framework to incentivise earlier prisoner cooperation to locate the remains of a person whose life was taken through homicide. We'll also provide the Parole Board of Queensland with the flexibility to manage its workload and the risks different prisoners pose to community safety. The police-related amendments included in the bill include expanding the scope of police banning notices to include people who unlawfully possess a knife, creating new indictable offences for persons who seriously injure or kill a corrective services dog, police dog or horse, including 9 Commonwealth child sexual abuse offences as reportable offences, 5 Commonwealth child sexual abuse offences as prescribed internet offences, and including the Commonwealth offences against children as disqualifying offences under the Working with Children Act 2000. It will allow for independent monitoring of surveillance devices by police employees, providing drug samples to law enforcement entities for national intelligence gathering, extending the current legal protections afforded to sworn officers from revealing police methodologies in a court proceeding, providing for efficiencies to the legislative scheme for assumed identities, and extending the court removal orders to apply to prisoners in police custody who assist police. Deputy Speaker, I will, however, expand on the amendments proposed to the Corrective Services Act. This includes amendments that will introduce a new discretion for the President of the Board to declare that a life-sentenced prisoner who has committed multiple murders or murdered a child otherwise to be known as a restricted prisoner, must not be considered for parole for up to 10 years. It will provide that a restricted prisoner subject to a restricted prisoner declaration must